Hi, boys and girls. One more evening of fun and frolic. So, as I was just mentioning to Braden, the idea of tonight is to give you a sense of what's going to be on the final. Can't give you the exact questions, I can't give you the answers, but we can talk about the subjects. So you have that review document that lists the chapters and says, here's roughly what you're going to get in terms of questions. You've got that list of terms that I suggest that you focus on studying. And then tonight, basically what I'm going to do is I've just got a set of notes that I'm going to start. There's really nothing out of chapter 1, so I'll start with chapter 2. I'm just going to kind of walk you through the rough subject. So again, if you take good notes or stuff clicks with you, then you'll remember a fair amount of this for your test a week from tonight, for those of you who are taking it face to face. It's also a good night for you to stop me and say, wait, I don't remember that, can you re-explain that? And if there's anything, it's a chance for me to make sure that there's nothing that I have missed. If it's something that I realize, oh, it's in my notes, I got to cover this, I didn't cover it for whatever reason during the lecture or during the class, so that you're guaranteed that there won't be anything on the final that we haven't gone over in the class. All right, so feel free to stop. Don't plan to do the math tonight. The math will be done on Tuesday night. So tonight's just about sort of principles and all of the text-based stuff. This is the majority of the review by far. We usually run pretty close right up to the end. It kind of depends upon how many questions there are and that sort of thing. So again, feel free to stop me any point along the way. We should have plenty of time. And if we don't get through it for whatever reason tonight, because there are questions, we have plenty of time built in on Tuesday night to finish up with final review, even without the math. So on Tuesday night, the math takes anywhere from 45 minutes to an hour tops. There really only are about 9 math questions on the final exam. So what I want to do there is sort of walk you through again one last time and examples on the board of how to do that kind of math. And again, give you a sense of how these questions will be couched so that a couple days later, hopefully, even those of you who are math challenged will have a sense of, okay, I think I remember that from just having done it. And then there's time left Tuesday night for basically about an hour worth or more of just questions and answers. So as you're studying or making notes tonight, or even as you're studying over the weekend, more importantly, write down things you're still not sure about and bring those to class on Tuesday. The way I deal with Tuesday's class is, if you're good with the math review and you want to leave after that, you will have fulfilled the requirements of the attendance of the course once you take the final exam. But if you want to stay and ask questions, you're free to do so, because they pay me to be here until 9:30 or whatever. So I'll stay as long as there are students here up until 9:30 or 10 o'clock Tuesday night if there's that many questions. So again, feel free to bring stuff back on Tuesday night to ask me to clarify things or whatever once you've had a chance to think about them more or review them or whatever. Questions about anything before we get started? Okay. All right, so again, there really are no questions out of chapter 1. It doesn't mean that there aren't valid or valuable subjects there. I'm just not testing you really much on anything real estate economics or the term realtor or anything like that. So let's get right into chapter 2. So chapter 2, I think the things for you to focus on there in general revolve around kind of those basic property law issues. So let me just give you a sense of things, questions that affect an agent, like what's real property and what's personal property. Anything in that chapter that relates to that, including something like trade fixtures, which can be a little confusing, right? Because with trade fixtures, it's got the word fixture in it, but technically, legally, it's not a fixture in the truest sense. So make sure you understand that specifically and those concepts in general out of that chapter number 2. Again, it's helpful to know things like where law comes from and all that, but I'm not going to ask you straight, basic general business law questions in the course. I'm going to focus mostly on stuff that I think matters. Right? So that's really it for that chapter. Trade fixtures and all of the other stuff that revolves around annexation, severance, and personal property versus real property. Chapter 2 is easy. So then chapter 3 has a bunch of principles in it about home ownership, affordability, different property types, things like that, again, all of which are important to know. Something that you'll be called on fairly frequently in practice to explain is the capital gains exclusion. Right? The idea that you can own that house for 2 years or longer and profit $250,000 as an individual, $500,000 as a married couple, as long as it's your principal residence, and not pay any capital gains tax. That's a big deal. And it's confusing to people, and if you don't think about it, study it, you might forget it. So again, I would just, in chapter 3, really look at that, make sure you understand that. So I could give you, for example, a scenario-based question, and then you have to figure out, is there a capital gain tax due here or not? If so, what's the dollar amount, or that kind of thing. So it's number $250 for an individual, $500,000 exemption for a married couple filing jointly, have to have lived in the house for 2 out of the last 5 years, and it can be any 2-year period. It doesn't have to be contiguous. It can be, 4 months 1 year, 3 months the next, and 5 months the year after that, and that would count as 2 out of the last 5. As long as it's 2 total years in the last 5. Just grab a seat up here. So that's chapter 3. Really focusing on that would be best. All right. So if you've looked at the document that I gave you regarding where the questions come from, the real meat of the course starts, and some of the most important stuff starts in chapter 4. Now, with that document I've given you that says a rough idea of where these questions come from, I keep saying a rough idea because many of these questions are in multiple places. And there's a lot of that between, say, chapter 4 and maybe 5 and 6, or 4 and chapter 14 because of the license law and duties and that sort of thing. So if you look at, if you ever add up the numbers, there's like 140, and there's only 128 questions final, but it lists like 140 different source questions. That's just telling you that a dozen or more of these are found in multiple locations. And I think I reminded those of you in this lecture class before that if something's in the book more than once, that really doubles the odds that you're going to see it on your final and as well as the state exam, because it's just that much more important. So the duties of an agent, all those fiduciary duties and the things you can do and shouldn't do, that's, there's a lot of that in that chapter. So this is really where you're going to want to spend some time. It's hard for me to say, oh yeah, only study this item on this page, because it's just not that simple. And again, it's not just passing your final here, it's understanding how to apply this stuff at the state exam. And so, we've got customer level services or duties, we've got the fiduciary duties of care, obedience, loyalty, accounting, disclosure, all that stuff are appropriate to know. We have agency issues of all sorts, from the type of agency, including things like dual agency, designated agency, disclosure rules. All of that that's in there is important. I'm not sure that there's much of anything in chapter 4 that doesn't matter a lot for what we do in business, and that could show up on your final. So since it could be 10% of your final exam questions could come from those subject matters, it's a place where you're going to want to spend some time and focus on all of that. When it comes to the license law, remember that I'm not going to ask you, say, the part of the text or the part of the license where it talks about ministerial acts, is that chapter 5 or chapter 15 of the act? You'll have nothing like that. But you might see something on the test that refers to a specific chapter or section of the law. That's not a trick part of any question you'll get from me. I don't care if you can find it right away. You can literally download the act and you can do a search and find whatever word or words you need. You don't have to have the act itself memorized on that kind of basis. But you'll see that language. But in general, again, you don't have to memorize sort of chapter and verse, but you have to understand the things you're allowed to do as an agent and the things you're not allowed to do as an agent and the things you're required to do as an agent. So I would focus on all of those kinds of things. Earnest money is in there. I think that shows up a few times. And again, there's some things in there that might relate to things in chapter 5. Term sponsoring broker and relationship between the clients and the agents and all that stuff. So that's all the more specific I think I need to be there. Again, spend a fair amount of time in chapter 4. Chapter 5, there'll be a question of some kind on antitrust. So you need to know enough about antitrust to know what kind of antitrust problem is it. Is that, the main things that I like to focus on with antitrust are price fixing and allocation of customers and markets, where you're doing those obviously and overtly competition limiting activities between you or your other offices or your competing agents or whatever. But then there are also those lesser known areas like group boycotting and tying. It doesn't hurt to know those as well, because they can show up as possible solutions. So again, you have something on antitrust. And the state exam is likewise. You're probably going to see something on antitrust at the state exam. and it's important in practice. We'll touch on that in one more case, probably in Real Estate 105. Then there are several statutes at the back of that chapter, like do not call, canned spam, and the Junk Fax Act. There'll be questions on at least two of those. So at least understand the basics of those statutes. Again, these are real in practice kinds of things where you need to know, can I call these people or can I not call these people? Can I, when I send out an email, am I doing it right? You know, just so the basics of what's in the chapter, make sure you understand those. What differences between an assistant and an unlicensed assistant? That's a good question also. So you'll see something on that. Who can do which or what? And who can't do which or what? Again, kind of chapter 5, kind of chapter 4, but that relationship between the sponsored licensee and the employing broker, anything that relates to that, compensation, employment agreement, you know, that whole thing, because that kind of forms the backbone of the business, so there could be a question or questions that relate to that. Including, you know, if you get into like the employment agreement, you can get into things as detailed as such as compensation. You know, again, if you're an independent contractor, you're not getting a salary. And if you're not getting a salary, you're not getting a company car, and you're not getting vacation time, and you're not getting benefits, right? I mean, if you're an independent contractor, you're a businesswoman or a businessman in that kind of scenario. We talked about that a lot in chapter 5. So you can get questions on that level of detail within that relationship. And then there'll be two different commission questions that we'll go over roughly on what they'll look like approximately on Tuesday night. So expect that. So if you have time and you want to kind of look at it ahead of time, know that there will be at least two different commission type questions on your final. Same kind of thing you should expect at the state exam. That and like land area or square area dimensions are probably the most common types of math questions along with finance that you're likely to see. Okay. I think that's pretty much it for 5. Chapter 6 has fewer questions, but again, some of these things kind of overlap. So a common sort of set of questions here and a common thing to know or to recall or understand from chapter 6 would just be the different types of agency agreements. So we talk about agency relationships, right, in chapter 4, and then we memorialize those relationships between the sponsoring broker and the clients in chapter 6. So understanding, you know, what's the difference between an exclusive right to sell and an exclusive agency and a net listing, for example, and being able to identify each is important. Same thing could be true for buyer agency, but most of those questions will tend to revolve around listing agreements typically. So learn those first, and then if you have time, study the buyer agency equivalents thereof. That would be my recommendation to you. And then other types of listing variations like net listings or that kind of thing, you know, remember that's up at the beginning of that chapter, so you can identify those. Knowing that net listings are legal, but they're a bad idea, and you know, if we describe a scenario, would you know if it's a net listing? You know, I don't care what I get, what you make on the deal. I just need to get 200 grand for my house. Everything over that's your commission. That's net listing kind of description. That's really it for there. And keep in mind that some of these things I mentioned won't have one question on them, they'll have 2 or 4 or whatever, because the subject area is fairly broad. And I'm, you know, that's as specific I can be for you on here, but that's kind of common. So I mean, like you see something like dual agency that shows up and you spend a fair amount of time on, it's clearly perilous, that's a high risk area as far as the state licensing agency is concerned, you know, DPR, and then it shows up and we spent more time on it again in chapter 14. That's the kind of thing you might see 2, 3, 4 questions on, something like that, spread across the test. Also, you know, we've gone through this course in material from 1 to 23 in chapters, and we're going through it in order roughly tonight. Your final exam will not be in that order. Your final exam will be in whatever random order it happens to be in. So be prepared for that, because it's helpful when you know, oh, I just finished chapter 4, this must be a chapter 5 question, and you're not going to get that on the final, nor do you get that at the state exam. Questions just come, random out of left field, however the system assigns them. So you just be prepared for that kind of different feeling if all of a sudden you're like, wait, why is my first question on a closing question or something? That should be at the end of the test. The test won't be laid out the way the book is. It'll be laid out however it happens to be laid out. All right, chapter 7, which many of you may remember is that first really ugly chapter that had a bunch of stuff in it that didn't sound at all like listing and selling real estate and making money. Bunch of questions from here. So you can, again, be given fact, circumstances, and then you have to sort of identify, what's an encroachment, what kind of easement, what type of freehold interest do we have here, what type of life estate do we have here, and that's 4 different possibilities. So you can get a lot of different fact-based scenarios that could cover any of those kinds of things. Again, including, so if we're talking about a life estate, it isn't just enough to know, oh, this could be a conventional, ordinary life estate, but rather, what's a reversion versus what's a remainder, anything within that context. Homestead estate is another thing to know. The particularly not only what it means in general, but also specifically like the dollar amount, who's eligible, things that go with that. One of the more interesting areas of that chapter, I think, is the sheet. So, make sure you know what that is, how that works. Somebody dies without a property, a sheet. Somebody dies without a property, and with a property, but without a will and without heirs. Where does the property go? Remember, we don't want any abandoned or unowned properties in the United States. That would kind of run contrary to our wanting to have all land submit to a highest and best use. So, it ends up being taken back by the county through a court action, and then the county's free to do with it what they want. So, that's something you're probably not going to see a lot, but it does happen, particularly in places like Cook County, where there's so many people who have properties and who pass on that there are inevitably properties sold by the public guardian in Cook County every quarter that the county ended up with through a street. Oh, and both, it shows up in chapter 7, but then also in chapter 12, both easement by prescription and adverse possession. So, so not only enough to be able to identify, oh, that's an easement by necessity, or oh, that's easement appurtenant, but rather when it comes to like prescriptive easement or adverse possession, be able to remember the rules, the 20 years, open, notorious, continuous, hostile use. By the way, I haven't told you this, but I possibly have an adverse possession claim on my property, my house. This one I gave you the survey for. People bought the house behind us and sent us a letter about 2 weeks ago. There's a little triangle because remember the survey I showed you, the easement at the back of my property. Well, it's got electrical lines running under it. So that house, which just borders on one of the corners of mine, they never put the fence all the way back to the property line because somebody didn't want to run fence posts probably through a 12,000 volt line. So the fence is off by 3 feet. And now the people wrote us a letter saying we want to reclaim our property. And I know it's been the way it is now for at least 28 years, 29 years. And so I talked to my wife, said, what do you want to do? And she said, no, it's our little piece of property. And we're talking about, like maybe 30 square feet of dirt and grass and peonies or something. So I don't know how it'll ever work out or whether I'll bother to write them back. I talked to all my neighbors who also got the same letter. There's 3 of us affected. So you never know. That's that fence sitting over the line kind of thing. So again, just know the rules of easement by prescription and adverse possession. The rules are the same for the 2. One is use and one is occupancy. All right, that's chapter 7. And just touched on a little bit of a few others there. So let's move on to chapter 8. And again, feel free to stop me at any point.
What was the easement by what?
Easement by prescription.
And the other one?
Adverse possession. And when you find them, you'll see that they're pretty much the same basic rule. So in chapter 8, we have our various forms of co-tenancy, which means you can get a range of questions about so-and-so and so-and-so own a piece of property, and somebody gets hit by a truck, and now the property's owned by this guy, how do they own the property? So that kind of question means for you to basically, understand that's the salient characteristics of like right of survivorship that only exists with joint tenancy or with tenancy by the entirety. You can get a question that'll say, that might refer to tenancy in common, which is the default option if the deed is silent. So again, those salient characteristics that we went over in class when we covered that, that's the kind of stuff you need to know about those. You're likely to get a few questions about that area. And then there were questions about, there were subject matter about condominiums and cooperatives and timeshares. So I would recommend you look at condominiums, cooperatives, and timeshares. If you're given descriptions of property ownership type, that you can identify which it is. And other than understanding business types like a corporation enough or a trust enough to be able to connect it to other things in the course, like the corporation that owns the co-op or the trust that's used in another deal, that's really it that I've got from Chapter 8. I don't expect you to know the difference between a corporation and an LLC and a partnership or a limited partnership and a general partnership. Most of that information was for edification, for clarification, for help. Yeah, but this is not, again, not a straight business law class, so focus more on things like the co-tenancy types, being able to tell them apart, the condos, co-ops, and timeshares, and being able to identify them. That's the most important. Those are the most important things from that chapter. So, Chapter 9. Chapter 9 is a good chapter for math also because you've got, land areas and calculating those and then converting from square feet to acres or whatever. So there will be, I think, 2 different questions that relate to math or that have math in them that we'll go over on Tuesday night. Again, I just want to restate to make sure everybody takes the time to look at this ahead of time, the basic length times width equals area formula, right? And to memorize, there are 43,560 square feet per acre.
Say that again?
43,560, how many square feet per acre. I mean, it's a good idea to memorize some of the other things that are in that chapter, like there are 36 sections in a township for the state exam. I'm not going to ask you that here specifically. But again, a kind of question you might get could say something like, which of the following is largest, or which of the following is smallest? And 1 or 2 of the answers require you to do a math calculation, and 2 or 3 of the questions require you to just know how big is a township, or how many acres are in a section of land, or whatever, right? So you can get this combination of memorization and math in the same question. And that's, again, I think there's some of those questions in the text or in the chapter at the end and in the practice module online, and that's a common kind of thing you can get at the state exam. So again, it's good to know more stuff, but here I'm mostly interested in, you understand the basics of each of those 3 survey systems. So again, if I give you a description, you'll know, oh, that's meets and bounds, oh, that's the rectangular survey system, or oh, that's lot and block. The rest of Chapter 9 we'll go over Tuesday night in a couple of math questions that we'll look at.
So you said for us to concentrate on what is the meets and bounds, the rectangle?
Yeah, right, for now, based on the 3 meets and bounds, lot and block, and rectangular survey system.
How much of it do you face in the real world?
Not a lot. You might, I mean, some of the things that we've talked about where you're looking at some unusual pieces of property and trying to kind of figure out where do they begin and end, that's what's happened to me, having some odd pieces of property where I'm looking at vacant land or something. So if you get into more complex stuff, not the typical house, you're likely to see that. But you still shouldn't be transcribing those legal descriptions or interpreting them or whatever. It's really the purview of a surveyor or an attorney. Even when I look at them, sometimes I go, God, this is really complicated, right? So I try and avoid that when I can. But yeah, for the average practitioner, not a whole lot. What you're more likely to see is it's your job to figure out, is this more or less than 1/4 of an acre? Is this more or less than 1/2 an acre? Where you're going to enter something into the MLS, and you're asked several things. You're asked the parcel size, which you can just take off a survey. If you remember, my survey was kind of odd. It had an arc and uneven sides and a back that was narrower than the front. But you could put it in the MLS as being 72 by 124 by 83 by, meaning just like an X, by whatever the other dimension was, 140. And so it would have these 4 dimensions, and somebody could look at that and go, oh, it's kind of a sort of a rectangle. And so there's that line. That's easy to do, right? You can just read that off the survey dimensions, or get that possibly even from a property card or some other public source of information. Then they will ask you how many square feet is the lot. And you say you could, if you want to calculate that, you can, but it's not necessarily an obligation to do that. But then there's a required field, just again to list a house. Is it less than a quarter acre, between a quarter acre and a half, between a half and an acre, between an acre and 5, and between 5 to 10 and 10 and over? And I mentioned, I think, to many of you this before, but it's really annoying as an agent to have somebody who's looking for at least a quarter of an acre to search on that field and pull up lots of properties that are well under a quarter of an acre, probably because the listing agent can't do the math. Or maybe because they're trying to stretch the truth a little. So like when we calculated my lot size, what we come up with like 0.23 something acres, I would list that as less than a quarter, because it's not more than a quarter, it's a mathematical fact. So I can put the dimensions up somewhere, and I can say in the verbiage in my description that it's approximately quarter acre lot. That's probably a little puffing a little bit, but it's approximate, right? It's pretty close. But I'm not going to click an absolute left-right data field and say it's to the right when it's to the left. So I mean, that knowing how to do that is pretty fundamental, even to listing a basic house. So the math is probably more critical than some of the other things in that chapter. And like I said, it's real easy to get a listing selling vacant land, and people do call you up and ask you for the price per square foot when you only know it per acre, or the price per acre when you only know it per square foot. And you got to be able to convert back and forth if you're going to do any vacant land sales at all. Okay, so we'll go over the math in more detail on Tuesday night. So, and there are no pictures or diagrams in this test. There's not, nothing out of that chapter that's going to be here's a township. Which one is it? I don't have anything like that. Okay, so chapter 10, where we're talking about liens and of various sorts and other burdens upon the property, real estate taxes, etc. At the beginning, we talk a little bit about some of the basic differences in certain types of liens. That liens are either voluntary or involuntary, that they're either specific or general. So understanding that basic concept is pretty important, right? So a general lien can apply to any property you own. Specific lien just to that one property, like the mortgage lien, for example. So you could be given an example, and then you have to identify which is it. Or you can get, a question that's, is it applicable? So, and these aren't all from your final necessarily, but they're the typical kind of question, many of which you've already seen, where you're given a scenario. Joe is late on his property taxes on his house, but not on his condo. What's the likely outcome? Well, the likely outcome is he could lose his house, but his condo is unaffected. What does that relate to? It relates to the fact that those are specific liens that only run to the one property. That's where you're applying this information that you know. There are several basic good-to-know consumer facts in there regarding property taxes. So besides the math question that you'll have that we'll go over Tuesday night about how to calculate a tax bill, which you've done in practice and we'll do again then, there are also some basic things in there like, what happens if I don't pay my taxes? So we have anything from that 1.5% penalty thing, per month that we looked at on the tax bill, to it goes to the tax sale. So you should know that, as well as the basic tax rate. Again, this part is not a math question, but remember, the tax rate is 1/3 for all properties in Illinois outside of Cook County, and I'm not going to ask you Cook County questions because we're not in Cook County. We're a long way away from there. So you should know what that property tax rate is. Again, you're a subject matter expert, so when you're talking to people, if you're at a dinner party, I don't care what it is, you should be able to say, oh yeah, whatever your market value is, you're taxed on 1/3 of that. But you also should be able to convert that to like 33.333% or whatever, right? Because a third and the percentage are the same thing. So if you can do that, that's probably helpful. I tend to think in percentages, because I always think about multiplying tax rates by things like percentages, but, fractions are the same thing, so however you want to look at it. So I think that's pretty much it from that chapter. I don't have any super complicated lien priority questions, other than what we talked about in the class. Remember, there was one mechanics lien question versus a mortgage lien at the end of that set of slides. So I would just recommend that you have a good sense of mortgage and mechanic lien priorities. And since we looked at a mechanics lien issue in class, for example, what are the rules about how long you have till you can file? Right, so if you've got to file within 4 months after your work is completed. But what about if you're a trade contractor on a big job? Forget about this building because you can't file a lien on public property, but assuming it's this building and it's done for a private developer. What if you're the window guy and you finish in August and the building isn't finished until February? When does your 4 months run? From August? From when your work is finished? Or from when the building work is done? Because that's the kind of thing that you could end up getting into, particularly if you manage property and you get up into construction stuff, it will end up mattering. It's when that contractor is done. Whenever that particular firm is done. It doesn't have anything to do with when the job is done. It doesn't happen very often, but it does happen from time to time, where trade contractors will file liens while a major project is still under construction, because that's the only way they have to protect their rights. Because you don't get paid all your money until the whole job is finished. There's some kind of money held back. And again, that relates to what we do, because if you manage property, if you do tenant build-outs, not everybody finishes on the same day. People finish sometimes months ahead. Okay, so that's enough for chapter 10. Chapter 11, which is all about contracts, etc. Some of the stuff in chapters 11 and 12 are very similar, so I may not say them both places, so I'll just state it now, but those essential elements, that are so similar between what makes a deed valid and what makes a contract valid. I focus mostly on what makes a contract valid, but those same things tend to apply to a deed, right? You have to have consideration, and you have to be of maturity or majority age and of sound mind, and for a legal purpose, meeting of the minds, all that kind of stuff. So all of those essential elements from the front end of chapter 11 are critical to know. Any of them are good grounds for basic contract-related questions, either memorization or application. We talked a little bit about kind of the negotiating process and offer and acceptance and what happens going back and forth, and I make an offer, what options does the other party have? So understand that process to the greatest degree that you can, because it's not at all uncommon, to get questions in that regard that sometimes are a little complicated, but they're very normal for real estate scenarios. So buyer A makes an offer to seller B, and they're negotiating back and forth, and all of a sudden buyer C comes along and makes an offer, after A and B have agreed orally, but before B has signed the papers. What are the options there? Or what's the role of the agent? Even after something's accepted, what's the role of an agent when an offer comes in? Go ahead.
What about when a broker and the buyer has like an oral agreement, and the buyer's out of town, and let's say a seller comes, sorry, I got mixed up. The seller and the broker have an agreement,
Okay.
and the seller's out of town, and the buyer comes in. Does there have to be a written contract that goes along with it, even if there's an oral agreement beforehand?
Yeah, so I think the answer to your question is yes, but let me make sure I understand. So I used to have a question similar to this before, and I think this kind of question is fairly commonly found amongst state exam materials, where the seller leaves their agent with some kind of oral instructions, maybe even to reduce the price. Doesn't even have to have a buyer involved. At a given date, if you haven't sold the house, drop it 20 grand. But that's all there is a conversation. Then the agent wants to do that, but can't reach the seller because they're on vacation on a beach or something or whatever. What does the agent do? The answer is nothing, because you can't do anything without written instruction. So even if you have oral instruction or oral direction, it's really not binding. And it's too easy for the client to say, I meant we were gonna talk more about it, I didn't remember it that way. So you always have to follow written direction. Is that, I was a little off maybe what you were asking, but it should be the same basic principle that fits? Yeah. So watch for that kind of thing, because questions can say to you, here are the facts, they work exactly like this, it's all oral, what are you gonna do? Right, so you only follow clearly written contracted directions. Particularly, remember, parole evidence rule, it's not really in the book, but this is the applicability of it, and the statute of frauds. When you have something in writing, no oral agreement will ever contramand that. Very unusual in the common law or statutory scenario like real estate, that you're gonna have an oral direction override any kind of written agreement whatsoever, or be binding in the absence of a written agreement. It might work in other areas of business where you've got two manufacturer and a vendor who do business together all the time. Those kinds of agreements under the Uniform Commercial Code might be binding. We don't have anything like that in real estate. So yeah, oral is probably usually pretty worthless. No matter how much you want to follow it, no matter how much the question leads you down the path of saying they agreed in advance, oral probably doesn't mean anything. Options. So we spent a little time on this, and it's not a real super common thing, but again, in the sample exam question, the sample exam that AMP has put out for years on paper, which was a 100-question test, which is just meant to be representative of questions at the state exam for the national portion. There are actually, in that 100-question thing that I first saw about 10 or 12 years ago, there are actually 2 option questions. So although you could go your whole real estate career and never deal with an option, option contract, obviously AMP and test question writers in the state maybe think differently. So know what an option is. So remember, in an option you don't really have a buyer and a seller. You have a potential buyer and an obligated maybe seller. Right, so the optionor, the one who gets or who grants the option, I got the terms right, I always get those backwards, and the optionee, the one who is going to receive that and has the right to exercise that option, it's a different term than buyer and seller. Right, so the person who has the option has the right but not the obligation to buy the property, and the seller, who really isn't a seller, has the obligation to sell only if that prospective buyer says, I'll do it, let's go. And it's usually 6 months, a year, year and a half. It's a relatively short period of time. So money is paid by the prospective buyer that the seller can keep if the deal never goes through, and that applies to the purchase price typically if it does. But again, it's different. Typical I'll buy your land and develop it is, I'll buy it contingent on financing, on zoning, on engineering, on everything working out that I need in the city. And if everything works out, you're obligated to buy or you lose everything, and could even be sued for specific performance. Under an option, everything could work out and you could still say no because you have no obligation to proceed. Land contract or an installment agreement is in that chapter, I think, chapter 11. Shows up again, I think, briefly in chapter 15. So there'll be a question regarding that. So this is where we introduced concepts like legal title and equitable title. It's also where we kind of talked about the right of the seller to declare the buyer in default if the buyer is not making their payments. So everything that relates to that you find in the book is probably a good thing to know. Again, you're talking about a question, but it's still worth knowing. Not something you're going to do a lot in practice, but I've been involved in a couple of them, have former students ask me about them. So it does come up, and it's something worth understanding. As creative buyers and sellers will look at trying to use them.
I have a question.
Yes?
How does a land contract differ from seller financing?
Well, part of a land contract is seller financing, but you can do seller financing without a land contract. In fact, I've seen land contracts go to seller financing. So let's assume that you've got a piece of property on which you have no debt, and I come along and I got marginal credit and no cash, and you're happy to sell me the property, maybe even a little bit above market, at an above market interest rate. We do it on a land contract. After 5 years, I still can't get financing, but you don't want to extend the land contract, and so instead, I refinance the property with you acting as the lender. There's an actual closing where a deed transfers the property to me now, so I have both legal and equitable title, and you now have a mortgage. You're now the lender with a mortgage. So that would be what would happen. The difference between a land contract, where as the vendor or the seller, you still hold legal title, and when we refinance it out of that and you remain as the lender, all you have is a lien. Does that make sense? I mean, I don't know why
So
you
it
would.
would all come foreclosure time would be the big difference.
Yeah, exactly, right, because when you're in that first 5-year period on a land contract, you don't have to go to court. If I default, you just take the property back and just, I mean, theoretically, you might end up having to go to court to evict me, but your claim would be that I'm now a tenant,
Okay.
right? And so it's not a sales contract kind of issue. It's more tenants' rights issue. And everything I paid to you is defaulted as rent, and I have no equity in the property and no claim against it. Whereas if we go beyond that period and I stay and I default, now you have lender's rights and you have to go to court and go through the judicial process, completely different situation. And again, you can do it either way. And both ideas come back to the prospect of having an income stream based upon interest over a period of time. So, and that can be a lucrative thing to do. I was just thinking about this today. I've been involved in, I don't know, a number of, 6-figure loans related to commercial real estate over about the past 10 years, and they've all turned out pretty good. And it's interesting to just kind of have that sense of, wow, we've loaned money out at as much as 18%, 10%, whatever. It's always secured by something. I don't know, it's an attractive feeling to do that kind of lending, not as a commercial lender necessarily, but as a company or as a group of people or whatever, and the returns can be pretty good. You can't force somebody to sell you their property, but you can offer to lend them money on it, in which case if they default, you can end up with it that way. In fact, when the market, I didn't mention this to you, but this is very interesting to me, and we have time, so don't freak out here. But so in 2007 and 2008, there were a number of cases where developers big development firms who really wanted to get their hands on a certain piece of property that they knew was in distress, went to the owner of the property, explained to them how bad their situation was, and says, so see buddy, since your life's about to come to an end, you ought to sell me your office building for a quarter of what it used to be worth. And of course they got thrown out of the office, get out of here, we don't want to deal with you. So what those very smart and resourceful developers did is they went to the lenders who were freaking out and panicking because they knew that thing was going to come back to them and they didn't want it back, and they could just see this horrific financial crisis unfolding in front of them. And they bought the note. They couldn't get their hands on the title, so they bought the note from the lender at the same kind of discount, and what did they end up with eventually? The property when that same party defaulted on the mortgage. Very smart, very resourceful. That's the kind of thing that you should be able to understand is doable just from taking this class, right? Because you can see that there's different ways to end up with property. Different sets of rights, different sets of risks, but it's a very doable thing. So yeah, that's a good way to be thinking, because there's certainly possibilities there. You may not be able to buy the distressed property, but you might be able to buy the distressed note, which will lead you to the property, possibly even more cheaply. All right, so I think that's pretty, I know I also was going to just mention, also in between chapter 11 and chapter 12 in the documents we went over, so now we're on kind of 11 to 12, making the transition here. You'll get questions both on deeds and bill of sale. If you remember, right, a bill of sale is how we transfer the personal property. It's mentioned in the book, but I also showed you a full-page example. And then, of course, deeds, which we're about to start talking about, full range of deed stuff that's in chapter 12. Okay, so to begin in chapter 12, before I forget it, remember this was the area where there's the one question that I mentioned that there is nothing in the textbook about this level of detail. So we looked at municipal transfer taxes in this chapter, and I pointed out that there are 3 questions that every real estate agent really should know about municipal transfer taxes on every single transaction you're involved in. First question, is there a transfer tax on this deal? Which really means in this municipality, whatever. Second question is follow-up, once you know that the answer is yes, that there is some kind of municipal transfer tax, question is, how much is it? What's the rate? Because the rate varies by municipality. So you have crazy things like in Chicago, where you have some goes to the city, some goes to the CTA, Bolingbrook, which is split between the buyer and the seller. Cities like Joliet, Elgin, Aurora, Glen Ellen, Naperville, or excuse me, not Naperville, which are all paid by the seller. Cities like Naperville, Wheaton, Chicago, others where the transfer tax is paid by the buyer. So that's another question. Once you know what the rate is, who pays it? So we know for the state and county transfer tax, we know the rate's fixed, and you should know those rates, but we know that that's by statute paid by the seller, consistently. Unless the parties agree differently, the standard default for the state and county transfer tax always paid by the seller. But the municipal tax, we have no idea unless we know the municipal ordinance or the municipal rule. So again, those three questions. Is there any on this transaction? If there is, what's the rate and who pays it? Those are the three questions. It's on the PowerPoint slides, in my notes that are up online, but I just think that's an important thing to note, and I don't want to forget to remind you that that's not really on that level of detail in the text. Okay, so while we're looking at deeds, various types of deeds, so just like we talked about with listing agreements, I guess, and I kind of skipped over this part of it, you know, with a listing agreement, you get a question, the seller sells the property themselves, the agent still gets the question, still gets the commission, what kind of listing agreement was it, and that would be an exclusive right to sell. You can have a similar kind of question that's sort of a quality of deed. What's the deed that has, you know, the 5 guarantees? What's the deed that offers no guarantees? So understanding enough about each of those, and I would focus mostly on general warranty deeds and quitclaim deeds because those are the two that are the most commonly used. Though once you go to the state exam, they can ask you a question about any deed they want.
You said general warranty.
Yeah, remember the samples we looked at just said warranty deed on them, but when we looked at the language where it said convey and warrant, we knew that meant it was a general warranty deed. I'm not going to ask you conveyance language level question, and I won't ask you to decide, you know, which of the 5 covenants is which within a general warranty deed, but I want you to remember that a general warranty deed is the one that has all the promises that run forever, and that's what a buyer really wants, because that's what anybody who's getting into property is going to want. A seller, a grantor, right, who's promised them, you know, I have the right to sell it, there's no encumbrances beyond what you know or that's in the public record, you can sue me for damages if I'm wrong, I'll remove the, you know, encumbrances if I didn't disclose them, and this runs forever, right? So, I mean, it's helpful to know that those kinds of promises in a rough form are all part of that general warranty deed. Whereas the quitclaim deed is what you use when you're just trying to get off title, or you're trying to say, I don't know what I have for an interest in the property, but whatever it is, here you go. Because that's really what a quitclaim deed is. I mean, you know, it's quitclaim, I like to say a quitclaim deed is the perfect deed to use to sell the Brooklyn Bridge. Because if your interest is nothing, the person gets nothing. If you happen to own the Brooklyn Bridge for some reason, then you've just transferred it. You're welcome. And then inside the deeds, again, not to a super level of detail. I'm not going to ask you to examine deed language. That's the purview of attorneys. But all of those essential elements that have to be there, sort of, you know, what are they and what kinds of things commonly affect deeds? So like under exceptions and reservations, for example, say deed's going to have exceptions and reservations, remember, because every deed here is always subject to the existing and subsequent years' real estate tax liens. We looked at those in the examples, it's in the text, so understanding that. Legal description's got to be part of it. And then, you know, we also talked a little bit about CC&Rs, you know, conditions, covenants, and restrictions. If those are applicable, those restrictive covenants are also going to show up. Not in detail, you don't get the whole book attached to it, but it'll just say CC&Rs or restrictive covenants of record. So again, identifying those things as being relative and relevant rather to a deed, you should be able to do at this point in time. I've already mentioned adverse possession, so again, you could get either one or both, adverse possession and prescriptive easement, but chapter 12 is where adverse possession shows up briefly. When title transfers is an important concept to me. Remember, it's not when the deed is recorded. We're kind of transitioning here between chapters 12 and 13, but so remember that it's when that deed is delivered to and accepted by the grantee, and it has to be accepted. If it's not accepted, there's no transfer. Here's my environmental wasteland of a property. I'm giving it to you. Hold on, I don't want that. Right? You wouldn't want to just accept something that would put you in the chain of title. And the example I gave you, that if I conveyed you my property and then stuck the deed in the drawer but never gave it to you and I died, that would never have transferred. So just understanding that sort of basic idea of when title transfers and how it transfers is pretty fundamental. It kind of happens really quickly in a real estate transaction and nobody notices but the attorneys and the closer and agents who are paying attention and who remember that. But it's pretty fundamental to what we're doing. And then either in, because I remember the two things are relatively similar, so I'm going to gloss over this in contracts, but it can show up in contracts or in deeds, and that is, you know, back to sort of the status of something, being valid, void, voidable. So you can get this in a contract question or you can get it in a deed question where it's just a fact pattern and you have to decide, what have I got? Do I have a valid contract? Do I have a valid deed? So a contract scenario could be, you know, something, you know, an example of, you know, A and B agree to, you know, sell the property or whatever, and B decides they want to get out of it before the closing. Can they? And that'll depend upon the facts. You know, if there was no consideration, if it was an illegal purpose, or B was a minor, or whatever, you'd be able to get out of it. Under deeds, you could have something like, again, a minor could be involved. Minors can inherit property. Right, so maybe I leave my property to my minor granddaughter or my minor son or something, and he inherits it, and then he wants to sell it because what does he want with my log cabin in Wisconsin or whatever? Can he? You know, I mean, something simple like that. Really, it can feel complicated, but you got to decide: is that you know, is it a valid deed if you leave something to a minor? Can a minor then transfer to somebody else? The answer is yes, so long as you recognize that the minor may have a certain period of time within which they could void that deed, right? Because it's voidable if you're dealing with them. Better that something's in a trust or something where they don't have that option. Yeah, all right, so then I think that's, if I got anything else here. Yeah, I think that's pretty much that for chapter 12, and just a little bit of 13 as it comes to like reporting and conveyance, etc. So one of the comprehensive things that you can get in a chapter 13 question is, which of the following is most likely to be recorded? Or which of the following documents is not likely to be recorded? So it's important to basically understand these various documents we're looking at well enough to say, okay, it's a deed, it's likely to be recorded. It's a mortgage, it's likely to be recorded. It's a subordination agreement between lenders, it's likely to be recorded. It's a lease, it's not so likely to be recorded. You know, the note is not going to be recorded, or the mortgage is. So as you go through and are studying these things, just keep that at the back of your mind, which of these things get recorded and which ones don't. It's a fairly long list of documents, but they're sort of, they make logical sense. The things that go into the public record are the things that need to give constructive notice, right, to somebody else about, hey, I own this thing, or hey, I've got a loan against this property. Beware what you do because I'm in the priority position. Those are the kinds of documents that need to be there. The note, which is the business deal, that's a private matter. That doesn't need to be recorded. What difference does that make? But the mortgage is critical because that sets the security interest and the priority date. With a lease, you probably won't record a lease. More likely, I think the text mentions if you wanted to, you'd record a memorandum of lease. But I don't see that happen all that often. It may happen more frequently in places like Chicago, but I've never done it out here. And I've certainly never seen anybody record like a residential lease. Don't know why anybody would spend the money. And then there's title insurance. So just, important things of title insurance. It eases the transition. So if some random seller makes you a bunch of promises that you can sue him if he doesn't really have title or this, that, or the other thing, it's like an uninsured motorist. What are you gonna do with them? You want the insurance. You don't wanna go after some motorist who rear-ended your car. You wanna sue Allstate or whatever. So it's the same thing with title insurance, right? And that's the whole reason that it's there. It gives people peace of mind. It also, that chapter's pretty clear that title insurance is what guarantees marketable title. Whose promises are we gonna really guarantee that the title is valid? Those of the seller who's just in a chain who bought the property from somebody else who claimed to be the title holder, or an insurance company who's done a search, who gets paid a fee to take the risk to pronounce that yes, in fact, we are convinced that this is a valid title. So all the things toward the end of that chapter, which are really just a few pages that relate to title insurance, I would get a sense of kind of what that might do. And just like with a mortgage commitment, with a loan commitment isn't a loan, but it's a promise basically from the lender to make a loan on certain terms. You have title insurance commitments also, where the title insurer makes a commitment to provide title insurance subject to whatever conditions. So I think that might be mentioned in there also. All right, that's it up through chapter 13. So chapter 14 has a lot of repetition in it. But there's a lot here. And remember when you go to the state exam that a lot of what's there is going to be from the license law and duties that come out of this area that are specific to Illinois because you have a whole Illinois portion of the test. And yes, Illinois portion of the test can focus on foreclosure processes in Illinois or can focus on other specific Illinois statutes like the Radon Awareness Act or how Illinois looks at other things. But a big chunk of what you're going to get at the state exam, maybe 2/3 of it, half of it, whatever, in that 40-question section, is probably going to revolve around license law, administrative rules, these kinds of things and how we deal with things. So, this is an important area to focus on. And again, a lot of this is repeated or comes from other areas of the text as well. So, basic things that are in there that you should be familiar with. Again, this is a place to spend a lot of time. You should know the name of the statute by now, right? The Real Estate License Act of 2000. You should know Administration and Disciplinary Board is what really runs the agency. I don't care if you know how many members are on it, but the state might. I don't care if you really remember the details about the Real Estate Education Advisory Council, but the state might. Questions about, at the state exam, a question about the real estate coordinator could be important, I suppose. Here I'm really interested in who needs a license. So anything that relates to that, and that's a pretty long list of possibilities. And even longer, the list of exemptions. So you could get, I don't know, this is probably one of those 4-question areas where, about who needs a license or which of the following need a license or that kind of thing. So there's a lot of detail there. Again, it's an important thing to know for practice also. Then the process of getting a license and keeping a license. You're taking a set of 90 hours worth of education. And you got to take a 30-hour broker post-license course in your first renewal period. And you got 6 hours per year of continuing ed after that for the rest of eternity. Even after you're dead, you have to take CE as a realtor. So it's, And so, those things are pretty fundamental, right? So what the process is, going through the education, passing the state exam, getting sponsored, and then, having to renew, how often you renew, what date, April 30th of even numbered years that your license as a broker would be renewed. what happens to your license, where does it go when you get it? Right, it's gotta be available for public display in the office. And, we're focusing, and I tend to focus on you all becoming brokers. I had a student come back to me one time and make a complaint when he came back to take the course for a second time. And his response was, well, you told us what, I'm gonna change the terminology because long enough ago it would be a little different, but he basically said, well, you told us what happened to a broker's license when it, when it was earned, where that got displayed, but you didn't tell us where a managing broker's license went. I hope you can make that leap of judgment application, right? That if you know that your license as a sponsored licensee has to be available for inspection at your broker's office, guess what the deal is with managing broker's licenses also? Just take a wild ass guess. So this is what happens, right? We're focusing really on broker stuff, and every once in a while, a question like that you're looking at, well, wait, we didn't talk about a managing broker, but it's probably the same thing. The managing broker has to have an employment contract. The managing broker has to follow the office policies and procedures. The managing broker is, is at risk for what you've done in most cases also. So even though I'm talking in the test and everything about this course is all about the broker, I'm not asking you managing broker questions unless it puts you in context of your relationship with the managing or sponsoring broker. But the state exam could ask you to make that little bit bigger judgment application. A little weird to me, but they can. So hopefully you can do that. Don't have to be too narrow in your thinking here. Something as simple as, why do we even have regulation? Why do you have to get a real estate license? What's the point? Why does the act even exist? Right? That should be pretty fundamental. But it's a big picture thing all of a sudden, not a detail thing. It's not something you would necessarily have memorized. But that should be fairly simple. Why do we have the License Act? Protect the consumer, right? Protect the public from us. We're the wolves all of a sudden. We're the nasty people who are out to make a living by charging them gobs of money to buy or sell or whatever it is that we're doing at the moment. So again, it's to regulate the industry and protect the public. Not necessarily a memorization kind of thing, but an understanding that that's the framework of the statute and why it exists. Well, I don't know if I kind of skipped this, but I talked about the name of the act, but also the name of the regulatory agency, right? Department of Professional Regulation or Illinois Department of Financial and Professional Regulation, either IDFPR in its spelled out glory, or just DPR, Department of Regulation, of Professional Regulation. Either of those, you should know that as well. That's the agency that you'll deal with. And you will deal with them from time to time. They'll send you stuff in the mail for renewals and things, and they're easy to call up on the phone. You could call them tomorrow if you had questions and wanted to. They don't ask who you are, so they're good people. And there'll be an advertising-related question. Since we just touched on that once in this chapter, you might want to go back and revisit that. Here's a list of kind of basic criteria. Right, can't lie, can't mislead people. Sponsoring brokers' information's got to be there. No blind ads. So there'll be one advertising-related question. It's really common at the state exam to maybe also see an internet-related advertising question. Slightly different technical answer, but I'm not asking about the internet, I'm just asking about it in general. All right, so again, there's a lot of questions there, at least as many as there are in Chapter 4, but some of it is repetitive. It said multiple questions about who needs a license and what are the exemptions and that sort of thing. So I think that's what I've got for Chapter 14. So we're about roughly 2/3 of the way through, maybe not quite 2/3, 65% of the way through the material, 60%. Do you want to just press on through and keep going, or do you want to take a 10-minute break? What's your preference? Okay, let's do that. Let's take a break. Let's come back at about 10 till or so, and then we'll pick up with Chapter 15 and go from there.